Good afternoon, and welcome to DFDL's Tax and Legal Aspects of Restructuring of Business in Myanmar webinar. I am joined today with my colleagues Diber, who heads DFDL Myanmar's tax practice, and my colleague Rohan, who is a very seasoned lawyer in restructuring side of business for our firm. Before we jump into the webinar, let me give you a brief introduction about DFDL in general. So we are an ASEAN law firm with presence in 10 countries, as you can see it on the map on the screen, with 12 offices. We are roughly 150 plus legal and tax advisors across 10 countries with 25 different nationalities. You can see the presence where we are and the practices which we undertake on the screen, including things like antitrust, aviation, banking, finance, energy, mining, infrastructure, dispute resolution, employment, importantly, restructuring and insolvency as well. I have already introduced the presenters today. I would be moderating the session. Rohan will be talking about the legal aspects of the restructuring of businesses in Myanmar. And Diber will cover the tax aspects of the restructuring. Overall, the agenda for today's webinar is where I'll give you a brief introduction as to the current situation in Myanmar, where generally businesses are under stress, leading to situations where restructuring could be in their mind and an option they might be pondering. Following that, we will give you a quick update about foreign exchange restrictions and the latest tax update overview, because these two aspects actually lead into and create the right preface for entering into and delving into the details and nuances of restructuring aspect in Myanmar. So, without much ado, let me give you a small little rundown on the brief overview of the present situation in the country. So as we know, there was initially an effect of a pandemic on businesses and consumer spending back in 2022, while majority of the regional jurisdictions did come out of it. Myanmar directly from COVID entered into a political situation where there was a government change and a military takeover, whereby a state administration council was established. A state of emergency was imposed in the country, and state administrative council took over the three sections of Myanmar, which is administrative, judiciary, and legislature. Following that, it led to effect on domestic and international trades, inbound foreign investments. There were banking downturns, and overall the economic and political situation remained troublesome since 2021. Importantly, we understand the depreciation of CHAT in comparison to USD, particularly the difference between the fixed exchange rate of Central Bank of Myanmar and the market rate, which is more derived from demand and supply principles, whereby exchange rate was CBM exchange rate is at 2100 Myanmar CHAT for $1 US. At the same time, the market exchange rate is 2900. So there is roughly 25 to 30% of difference in the prevailing exchange rate, which again leads on to the distress as businesses find themselves in a bit of difficulty while procuring US dollars for their activities. Following the political situation, we did see, foreign investments in many sectors exiting and or reducing their commitments. Importantly, in sectors like oil and gas, infrastructure, to some extent, manufacturing as well. Following which, in 2022, Myanmar was blacklisted under Financial Action Task Force, blacklisting protocols, and which led to certain distress on the banking transaction. However, let's understand it's more of a scrutinizing than an embargo to transact with banks for egress and outgress of monies in Myanmar. To overcome such difficulties, Myanmar devised certain measures. That is to say that direct settlement between yuan and Myanmar Chat, direct settlement between Baht and Myanmar Chat. And at the same time, we understand there is something similar in pipeline with Indian rupee and Myanmar Chat, basically factoring most of the border trade situation to be directly settled into respective currencies in question. Now, this being the preface, I think so before we delve into the restructuring aspect of it, I would like to call upon you, Rohan, and it will be interesting to understand how did the entire de-dollarization unfolded, and what are the recent updates briefly, but it will be good to know. And it'll be good for our audience to understand as a refreshing aspect of it. Over to you, Rohan.
Thank you, Nishant. Yes, with respect to foreign exchange restrictions and de-dollarization, over the entirety of 2022 and now recently in 2023, there have been a host of CBM notifications, issuances, and announcements. Now, it all started with the fact that any foreign currency which was hitting the bank accounts was mandatorily being converted into Myanmar Chat. That's one such notification. Then any payments of any contractual payments in Myanmar, it was all being done. I mean, the CBM issued an instruction that everything needs to be done via Myanmar Chat itself. Now, that being the preface, over the last 6 months or so, we've seen that there have been certain exemptions and relaxations. For instance, in the latter half of 2022, there were certain exempted entities which did not have to mandatorily go through this entire process of conversion, such as the MICM entities, so on and so forth. And now again, recently we've seen that the CBM has said that any foreign company, which is a company with more than 35% foreign shareholding, does not need to mandatorily convert into MMK, the foreign currencies which hit their bank account, and they can use such foreign currency for their internal use or sell them to other banks. And so we see that there has been some sort of relaxation. But also with respect to another factor, which is sending out money out of Myanmar, there has been a lot of issuances, operating procedures. You need to check every sort of remittance document, and the MOPF and other sort of ministries, authorities have been coming out with guidelines to sort of completely scrutinize this entire process. So that's where we are at with respect to foreign exchange coming into the country and leaving the country. But if we please move on to the next slide. Um, Recently, over the last week or so, we've seen that with respect to payment transfers relating to imports, the government departments have been emphasizing on verifying the entire licensing of the relevant entity. And also they've said that the usage of advance payment telegraphic transfers for imports is prohibited, while with respect to certain exports of commodities, with respect to cross-border trade, utilizing an advanced telegraphic transfer system is permitted from July the 2020. So basically, we see that there have been restrictions, relaxations, and this is an ever-changing market. And but DFDL will be issuing a compendium on all the recent banking and finance updates. So I request all clients and all our listeners to tune into that for further updates with respect to these matters. Yeah, over to you,
Thank
Nishant.
you. Thank you, Rohan. And in fact, that compendium is continuation of what we had done in 2022,
Yeah.
where we had captured the updates for last 2 years, that is from 2021 up to the issuance of the compendium in I think so June 2022. And from then we are capturing it up to the date of issuance in 2023. So together would be a composite guide as to how the financial situation in the country has unfolded since the political situation. Thanks, Rohan. Diber, to set the tone right, to understand from de-dollarization what further updates have happened, particularly from a tax perspective. Importantly, the recent the laws of 2023, it'll be good to have an overview before we get into the core of the discussion today.
Okay, thank you, Nishant. So in terms of the tax updates, the Myanmar government has issued the 2023 Union Tax Law. So in the 2023 Union Tax Law, the tax rates are, for each tax types are specified there. So we have included here an overview of the applicable tax rates. So the first one is on corporate income tax. So corporate income tax is the tax on the income of the company. So the income tax rate currently it's at 22%. If the company is in an oil and gas upstream or it is listed in a Yangon Stock Exchange, then the rate would be at 25% or at 17%. There is also a commercial tax in Myanmar, which is similar to a VAT system in other jurisdictions, wherein the rate is at 5%. There are other rates applicable, for example, for sale of building under lease or under construction, jewelry, and for all other types of sales listed in the Union Tax Law, they can be covered by a separate city rate. But in general, the rate is maintained at 5%. Now, in terms of withholding tax, currently Myanmar does not have any withholding tax on dividend payments, whether it's made locally or to foreign companies. In terms of interest payments, the withholding tax is exempt if given locally, but if it's made to a non-resident, including a branch of a non-resident company in Myanmar, then it is subject to 15% withholding tax. The rate can be reduced under an applicable tax treaty with Myanmar, or it can also be exempted on certain cases, like transactions under international tax or international agreements with Myanmar. In terms of royalties, the rate for non-resident is still maintained at 15% withholding tax. So in the case of services, the rate is also maintained at 2.5% withholding tax. The recent update for 2.5% withholding tax is payments to overseas suppliers or overseas service providers will generally be subject to 2.5% withholding tax. You can be exempted if the offshore services if the services are performed entirely offshore, but that needs a prior confirmation from the tax office. And at the same time, you can also be exempted on withholding tax if the non-resident service provider does not have any tax presence or what we call a permanent establishment in Myanmar under a relevant tax treaty. A key point for business restructuring discussions which we will have in later on slides, would be on capital gains tax. So capital gains tax applies on any sale, transfer, disposal of capital assets. So capital assets include land, building, shares, and it's generally at 10% of the capital gain. But if the company is engaged in the oil and gas sector, they will be subject to 40 to 50% capital gains tax based on capital gains on the sale of those capital assets. In terms of tax treaty network, Myanmar currently has 8 tax treaties. It's mostly with ASEAN. And in terms of, we have DTAs with UK, also with South Korea, and as well as India. For transfer pricing rules, currently there is no transfer pricing rules, official transfer pricing rules. There is a mention of transfer pricing or the principle of arm's length in a public ruling, but there is no specific guidelines as to how the assessment of an arm's length or a transfer pricing guideline would be implemented in Myanmar. So these are the preface of the applicable taxes that we will consider in assessing for business restructuring.
Thanks a lot, Diber. And I think so this sets the tone for the main content of today's webinar. And I would call upon you, Rohan. We understand this has been a primary practice for most of the firms practicing in Myanmar, the restructuring in general since 2021 up till now. Based on your experiences, what are the main forms of restructuring which you have seen in the country? A broader overview would be very helpful and would set the tone right for the discussions going forward.
Thank you, Nishant. Yes, with respect to business restructuring, we've seen over the last year or so, there have been operational restructuring with respect to, from the labor side, the loan or debt restructuring side. And a lot of companies have actually scaled down their operations. They've, handled labor, and we'll discuss it in a bit when we proceed further in our presentation. Apart from that, we've seen share sales, we've seen indirect and direct transfer of shares in Myanmar, as well as asset sales. So we've worked on a lot of these transactions where there has been some sort of distressed M&A sale, and yeah, so that's another form which we've seen. And finally, final restructuring option which we've seen is basically, companies have been winding up and exiting, and so that's a long drawn out process. So yeah, that's also something to discuss and talk about when we sort of discuss further in our webinar.
Sorry. So primarily, if I can summarize it, we have seen a total of 4 to 5 kinds of restructurings, which generally happens. The first being the share transfer aspects of restructuring, that is an M&A, distressed M&A or something of that sort. Yes. Second being the organizational restructuring, that is being the labor side of it, cost-cutting measures and things like those. Third being, say, external commitment restructurings, which could be like your debt restructurings or your restructuring of payables with your third parties, etc. And fourth, obviously, is the winding up and exiting in general. Good, yes. Great. I think so. This does have the overview of what we would say what we have seen as a practice. And to follow up from here, Rohan, let me ask you certain questions particular to, share transfer. And I'm just trying to factor direct transfers here. Yeah. That is onshore direct transfers. What are the steps to be undertaken before a direct share transfer of a DICA company can take place? Follow-up of it would be, I'm going to ask these three questions, and then leave the floor to you and Diber. And Diber, please pitch in from a tax perspective as well. So first being the direct share transfer for DICA companies. Second, what are the differences when it comes to MIC or SCZ company? And any regulatory approvals required for these transfers?
Thank you, Nishant. So I will start off with talking about DICA companies, which are basic service companies and don't have a host of licenses, but just on the ground. Yeah, so basically for DICA companies, what we first would do is check for compliances like, JV shareholding ratios based on the sector. For instance, if after the share transfer there is any foreign shareholding, etc., we'll need to take those into account, because that directly impacts the the level at which you can undertake the transfer. We'll look at the loan agreements on the change of ownership clauses. We'll see what needs to be done with respect to those specific debt relationships with the banks and financial institutions. And we'll also have a look at any third party agreements and restrictions therein. So that will comprise our DD process in a nutshell for a DICA company. And then after we've taken those steps and we've sort of mitigated any restrictions, we move on to executing the share purchase agreement and executing the share transfer form. Now, with respect to these particular agreements or instruments, if I may say, Diber will explain the stamping aspects of it in a bit. So after that, what we do is or simultaneous to this execution, what we do is we update the register of members, which is a register which is maintained by the onshore company. And once that is done, share transfer is completed. And then after 21 days of this process, we need to, or within 21 days of this process, we need to register these transfer of shares with the DICA on its online platform, the Myanmar Companies Online. So this is
probably
for
probably also issuance of the share certificates within the stipulated period of time.
Yes.
Okay, please go ahead.
Yes, and now having this broad framework in mind, we'll just look at companies which have which are MIC companies and SEZ companies, because that takes another step before the transfer can be made, which is with respect to the regulatory approval side of it. Because the MIC direct transfers, if it's anything more than 50%, and if it's a transfer to a non-related party, then you need a sectorial approval, or you need the approval from the MIC. A very similar concept is underlined in the SEZ laws as well. And there are sectorial licenses which you have. I'll just give an example of the telecommunication sector, which is the Posts and Telecommunications Department. So you need to take an approval before you can move ahead with the transfer. I mean, what you can do is you can have in place the entire share purchase agreement and everything done and discussed between the parties. But I mean, the completion of the transfer will ultimately depend on these approvals moving through. So that's an additional point which I wanted to highlight. And while there are no merger thresholds yet in Myanmar, we've seen the Competition Commission also intervene in certain cases. So that's another angle which entities wishing to transfer shares will need to look at, or maybe consider when filing applications. Yeah.
Thanks, Rohan. And particularly with respect to, say, telecom sector, am I right to say, Rohan, that there is a merger threshold prescribed under the telecommunication competition rules, and which apply to, say, the telecom sector? And there are certain examples where we have seen actually a proper report, which could just be shy of a snip test being mandated by the regulators for approving any share transfers in telecom sector. Something which you may want to, without much information, but something which you may want to share from our recent experiences.
Yes, Nishant, thank you. So, especially with respect to the telecommunication sector, we have the competition rules for the telecommunication sector, which prescribe certain guidelines. And in our very recent experience, what we had to do was both involve the Post and Telecommunications Department as well as the Competition Commission. They asked for very detailed analysis on the competition angle from an appreciable adverse effect test perspective, and it went on for quite a few months with respect to this entire analysis, and it was just shy of a snip test. So I mean, in I for with respect to other sectors, we've not really seen this happening at this length, but for the telecommunication sector for sure, especially because there is a framework in place. We have seen quite a detailed competition angle to it as well, Nishant. Yes.
Thank you, Rohan. And for those who don't are not aware of what does a snip test mean, basically means small. I mean, the full form of it is small but significant and non-transitory increase in price, right? So that is to say, how does an M&A affect the market in general, and how would the competition with the other players in the market be affected, and how dominant will a player become to be able to regulate or control the price of the market. Thanks a lot, Rohan. That was interesting. Diber, we would like to now come to you, and particularly would like to understand the tax elements of direct share transfers, onshore share transfers, and how what you have really seen in your recent experiences, and particularly what sort of rulings you have tried to procure for any M&A share transfer, where there may have been certain ambiguities in respect to, say, par value versus value, and things like this.
Okay, thank you, Nishant. So in terms of a direct share transfer, so first there is a tax notification requirement for the company to notify the IRD on the changes on the Myanmar company to notify the changes in the MICO to the respective tax office generally within 15 days. There is a provision under the tax administration law that allows for a 1-year notice, but in general we follow the 15-day approach in relation to a transfer of shares in a company. Now, with regard to the application of the taxes for a direct transfer, so basically there are two types of taxes that would apply for this transaction. One is the capital gains tax. So when the company, when the selling shareholder sold its shares in a company, any gain on those would be subject to capital gains tax. So the issue on determining capital gains, it's not the existing tax rules are not specific enough to qualify how to calculate the value of the sale, and cost of the sale for share purchases. So in general, the IRD follows the selling price as stated in the agreement or in the sale purchase agreement. But the IRD also has the right to allocate or to consider any amount that is considered the current value of the transaction. So in the case of sale of shares, it may be possible that the IRD may use the current value of the sale based on the existing financials of the company, or it may also be considered in the form of the value of the sale per disclosed with the DICA. So this remains still an issue, but we have seen that the IRD is questioning some transactions that they deem insufficient on determining the capital gain. Another point is on stamp duty. Stamp duty, it's basically 0.1% of the value of the sale. So same with the case of capital gains, there's also no definition or clear guidelines under the Stamp Act on how to determine the total value of the sale. So the approach for capital gains and capital gains tax and stamp duty would generally be the same. So for stamping purposes, the amount indicated in the share transfer form is deemed as the amount or value of the sale for stamp duty purposes. Now, we have seen most of the cases where a company would execute first a share purchase agreement, and at the time of completion of the transfer, they would execute a share transfer form. So the current practice of the tax office is to apply two stamps or two stamping transactions for each type of agreement. Sale purchase agreement would generally be subject to a maximum of 150,000 chat, or roughly around $80 stamp duty. And the principal stamp duty would be applied on the share transfer form. Now, the stamping should be made on or before the execution of the agreement if it's executed in Myanmar. But if it's executed outside, you can have it stamped within 3 months from the time that it was first brought, or the agreement was first brought into Myanmar. Now, another aspect for share transfer is in relation to availment of any tax relief under a double tax agreement. There is an article in most of the DTAs in relation to capital gains for the sale of shares or sale of capital assets. Normally, if the company is not principally consisting of immovable property, or meaning the company has less than 50% of immovable properties, there could be an exemption under under a DTA with Myanmar. In the case of Singapore, they have a threshold, so they would consider a portion of the sale, and at the same time, the percentage shareholding of the shares. There is a 25 and 35% threshold or ratio under the DTA. So for DTA purposes, if the company is availing any benefit, it's not currently automatic as compared to other jurisdictions. In Myanmar, you need to apply beforehand to the IRD or to the respective tax office before you can avail any of the tax treaty benefit. The last point is on the assumption of tax liability to the new owner, because in the case of a direct sale share transfer, the purchaser would become an equity holder of the company, so it also absorbs any existing liability of the company. So this also must be considered when drafting or negotiating arrangements with the seller.
Thank you, Diber, and I'm a bit conscious of time. So with that, Rohan, I'll quickly call upon you because most of the things which we have discussed about direct share transfer, to some extent, at least from the approval perspective, apply in indirect share transfer also. And even if there is no onshore changes happening, there could be an ultimate company change requirement in their filing. So could you please quickly touch upon that?
Yes, Nishant. So from an indirect transfer perspective, I think it's pretty much the same that we've covered in the past slide based on approval requirements from the MIC and the SEZ, the PTD. Those apply. We need to check for third-party agreements if there are any restrictions on ultimate ownership, and ultimately if the ultimate holding company is changing, we need to update the DICA within 21 days of the transfer taking place. So, and yeah, but of course there are some sectors which don't require the need of this approval. So that's entirely based on the particular sector. So I mean, just to keep it short and brief, I'll stop there.
And from your experience, how long do you see generally these approvals were necessary taking? How much time have you seen?
Yes, Nishant. So for the larger it's dependent on the transaction. So for larger transactions, we've seen approvals take maybe 8 to 10 months. And for smaller, or rather, I would say transactions where everything is already sort of informed to the relevant ministries and pre-processes have been taken place already. For those, we've seen approvals come to within maybe 2, 3, or 4 months. So it depends on the scale to a great extent.
Noted, noted. And I believe, from the recent aspects, what I have seen or I've heard, it seems like Myanmar Investment Commission is not convening, the body is not convening for a long time, and thus the approvals have not been forthcoming recently. So there could be further delays than the envisaged timeline. Diber, let me call upon you and quickly learn from you as to what are some of the important tax related aspect which people have to consider in respect to indirect share transfers. And let's just cover the important broader parts so that we can move on to other topics from other than share transfers.
Okay, so for the indirect share transfer, the main consideration here is on capital gains, because the definition of a capital gain for an indirect share transfer would somehow be covered under the existing income tax rule. So the scope of capital gain covers any other form of any other form of transfer. So that definition can also include indirect share transfer. But the issue here is, in practice, it's not clearly being applied, and there is no mechanism for the IRD to determine how indirect shareholding or indirect transfers would attract Myanmar tax. So we normally suggest clients to get a ruling confirmation on this to get clarity from the IRD.
Thanks, Diber. Thanks. So this was about share transfer. Rohan, what about asset transfers, right? I mean, what are the restrictions, if any, including transfers of immovable property where necessary? What sort of regulatory approvals you would see in such transfers?
Yes, Nishant, thank you. So for asset transfers, both the MIC and the SEZ, they've sort of in the regulations said that 50% or more, if there's asset transfer, the Myanmar investment regulations needs an approval. As far as the SEZ rules are concerned, so at the time of application, certain undertakings were already given by the specific companies while getting the SEZ permit. And if there's any change or if there's any sort of deviation from what had been submitted, you need to take an approval. So from a regulatory perspective, asset transfers need approval. Now there are license conditions with respect to specific sectors, and you need to check your licenses on particular restrictions as well. And now, especially with respect to, immovable property that has been secured. So the point here is you need to, there's a requirement for the lenders to release such immovable property before you can actually transfer these assets. So, I mean, a diligence needs to be done on those aspects as well from an asset transfer perspective.
Thanks a lot, Rohan, and very clear. Diber, what are the tax considerations of asset transfers, if any? Quickly,
Yes, so,
as to broader pictures of what are the tax considerations.
Yeah, so the first thing you need to consider for an asset transfer is in terms of valuation, because if it involves immovable properties, then it needs to be valued first by the relevant authority in the covered jurisdiction. So after getting that valuation, then the taxes would basically cover capital gains tax. So capital gains is also at 10%. Stamp duty in the case of an immovable property, it would be at 4%. There could be an additional municipal taxes. Commercial tax or specific goods tax would apply depending if it involves inventory transfers. Property taxes would also have to be considered if you are transferring immovable property. And for for Myanmar citizens, the tax on undisclosed sources of income, or considered the income escape assessment, would also need to factor when buying or purchasing products. So aside from those general taxes, in the case of an MIC and SEZ companies, if there is an export transaction on machinery, equipment, or similar items, then any benefit that you have received at the time of importing those items would have to be repaid when you sell those domestically or for export. There is also a potential relief for DTA application, but rarely we have seen this being applied for an asset transfer in Myanmar. And similar to share sale, there is also the assumption of tax liability of the new owner of the asset.
Interesting. And you did talk about something with respect to 4% of stamp duty applicability on a conveyance of immovable property. Could you enlighten us whether this only applies to certain locations within Myanmar, or it is writ large across Myanmar?
Yes, so the 4% is generally applicable across all, all regions in Myanmar, but there are some cases that you have to also consider municipal charges depending on the region where the property is located.
And additionally, to add, I believe there would be a registration charge as well, because for immovable transfers, there has to be a registration necessary, and that would be roughly around 0.5%, if I'm not wrong, of the value?
Yeah. Yes, it's generally 0.5% to the ORD.
Okay, great. Thanks a lot, Diber. Very interesting. Vate, can we go on to the next slide, please? Rohan, I mean, we did talk about general share transfers and asset transfers. But what if a company doesn't want to sell or downsize? What if they just want to have operational structuring around what they are doing? And in that case, say, let's talk about loan restructuring, right? So from a loan restructuring, what sorts of process generally are to be followed? And what kind of approvals would be necessary? Let's touch upon this a bit quickly. Some broader, interesting pictures about what is required.
Yes, Nishant, thank you. So from the perspective of loan restructuring, we've seen quite a few, amendments with respect to the repayment schedule, and that's where lenders and borrowers are sort of agreeing upon a different rescheduling of the repayment. So that firstly requires your documentation changes and amendments. So you do that, and then if it's a cross-border debt, then what you do is you need to go and take the approval of the CBM, because in the first place, while taking the loan, this was approved by the CBM. So that's the first sort of approval requirement that you have. And then another very interesting point is with respect to the MIC, which I wanted to talk about, is that if as a result of such a debt restructuring, if there's a change to the debt equity ratio, which you had previously submitted while applying to the MIC for the permit, you need to go and report it through the quarterly or annual report update as well. So that's also something we need to consider while restructuring debt obligations. And generally, in terms of timeline, we've seen approvals being given in 1 or 2 months, or they've actually gone on to 5 or 6 months as well. So it's dependent on when the authorities meet and the scale of it as well.
And thanks, Rohan. And before I pass the baton to Diber, how difficult or easy is it to get these approvals, particularly keeping in mind the recent banking situation and the overall embargo which we see in the market on repatriation of debt?
Yes, Nishant. So recently, I mean, these approvals, maybe over the last year or so, they've been getting difficult because the CBM has various layers and they've actually introduced separate departments. So I think over the last 6 months, it's getting tougher than previously. So yeah, I mean, that's my comment on the difficulty standard. But But again, on a positive side, we've seen that the CBM also come up with a lot of relaxation. So maybe in the future we'll see these approvals being more streamlined and faster paced. So that's all that we can hope for maybe at this point in time.
Thanks, Rohan. And Diber, quickly to touch upon the loan restructuring angle, and an additional question to you would be, are there any thin capitalization rules in Myanmar, or something on lines of, say, interest deductibility when we are thinking about loan restructuring?
Okay, thank you, Nishant. So currently there's no thin capitalization or an interest limitation deductibility for Myanmar. There is an avenue of contest for IRD in case it's not considered commensurate to the volume of the business of the company, but generally interest expense can be deductible for tax. So in terms of loan restructuring, it really depends on the type of financing or the type of restructuring on the arrangement. So if it's just an amendment of the term of the loan, normally it's just stamp duty, a minimal stamp duty would apply. If it involves conversion of loan to equity, normally there is no tax that would apply unless the transaction could be considered as a constructive payment of an interest or constructive payment of an existing payable that should have been subject to 2.5% withholding tax. In cases of offsetting of loan repayment with other types of advances or payables, there is also generally not taxable unless there is difference on the transaction and it may result to a gain or an income on either of the parties. And for cancellation of debt or loan forgiveness, it's generally considered as taxable from the perspective of the buyer. So for these types of arrangement, the arm's length and the transfer pricing consideration should also be factored in when doing these types of transactions.
Thanks, Diver. And needless to say, and please correct me if I'm wrong, there would also be, though minimal, stamp duty obligations on the restructuring documents.
Correct, yes.
Thanks a lot, Diber. That is very clear. And with this, I guess we get to the last leg of the restructuring option, which we have been wanting to talk about, and that being the liquidation or winding up of an entity. Now, with that in mind, Rohan, let me call upon you and try and understand and gauge through you as to when do you when under Myanmar laws can a company file for a voluntary liquidation? What are the steps involved? What are the processes around, say, the company has certain licenses? So what are the processes around surrendering of licenses? How does a company prepare for a voluntary liquidation? And what is the process for an overseas corporation, which was a subsect of it, which is a slightly different position as compared to companies?
Of course, Nishant, thank you. So we have been assisting with a lot of these liquidation requests of late. Now, the first thing which I would like to point out is the fact that a voluntary liquidation by members can only be undertaken by solvent companies. If it's not a solvent entity, it has to go through a separate route via rehabilitation, or maybe if the creditors sort of get in and apply. So since we are talking about options from the company itself or from the members, it has to be a solvent entity. And before going into the liquidation step or the winding up step, it's important to have a preparatory process in place, which means you take the approval from your line ministries as well as the MIC and the SEZ where concerned. And as part of the regulatory step, you also look at the various different options which are available to you with respect to approaching the labor authorities and keeping in mind the labor restructuring options, because for all your employees, There is a severance payment which needs to be done if the company is shutting shop. So you look at those aspects as well. So a lot of DD around employment claims, third-party contract termination. Uh, so you need to do a full-scale DD on where your company is at this point in time to be able to successfully prepare for a voluntary winding up, which also maybe your debt obligations need to be cleared off. If there are debts with your shareholder, maybe a loan forgiveness, which actually does not need an approval, but just a notice to the authorities. So all of that needs to be prepared before you get into this entire voluntary winding up stage. Now, once that is done, what happens is your director needs to, or your board of directors needs to come up with a certificate of solvency of the company. And within 21 days of the director's solvency statement, there needs to be a members resolution where the winding up is resolved upon, and the company is put into liquidation where a liquidator is also appointed. So once the liquidator is appointed, the operation of the company is entirely in the hands of the liquidator, and the board ceases to have any control. So thereon, it'll just be, the liquidator taking control of the entire process, selling assets, and taking all the processes to be completed throughout. So yeah, that's with respect to a company. Now, with respect to an overseas corporation, previously branch and rep offices, the process is much simpler. You need to deregister with the DICA, which is an online process. You have a form called Form E9, which you file with the DICA. You take a board resolution from your parent entity, and within 60 days, your company is deregistered from the records of the DICA. So that's the entire process from my side.
Thank you, Rohan. And interesting to know how you talked about front-ending the due diligence. And that is a 360 due diligence to understand what your liabilities are and to clean the books of the company before hitting the liquidation, so that there are less observations by the liquidator once the process starts, because you don't, as a director, have any control of the company at that point of time. So that's a very interesting point, and thank you for that. I'll again get back to you. But before that, Diber, some of the tax considerations with respect to voluntary liquidation.
Okay, so for tax, there's no distinction between voluntary liquidation and deregistration. So from the IRT's perspective, the process would be the same in those cases. You need to notify the tax office within 15 days from the time that you have applied with MICO, or at the time that the board resolution already passed that the company is undergoing liquidation. You also need to still comply with the filing or tax return compliance until the year of the liquidation or the year of the deregistration. The most critical part here is in terms of tax audit and securing of tax assessment, because before the company would issue a tax clearance on account of closure, they would still look at your past open years, which they can go up to the past 7 years in relation to your transaction. So tax audit process normally is would be a bottleneck in terms of getting a tax clearance, which is required for tax liquidation purposes.
Thanks a lot, Diber. And that means you should probably apply for tax rulings a little in advance as compared to other situations, correct?
Correct, yes. But in some cases, it also depends on the existing tax compliance of the company. That's why it becomes a delay, or it could prolong the liquidation process.
Correct. And probably that is the reason why we also have to have the onshore data retention for a considerable period. That is to 7 years at least from the date of liquidation. Is it correct?
Correct.
Thank you. Thanks a lot, Diber. And Rohan, so again, summing it up. So how easy or difficult is the whole process? What is the general timeline you would see in cases of companies which is fairly large operation, and that can obviously give a perspective of smaller operations will be fairly quick. And again, sum it up together pretty quickly. We are now hitting the deadline, and some of the key considerations when planning a restructuring, from a legal aspect.
Yes, Nishant, thank you. So very quickly, liquidations generally, in our experience, they've taken anywhere between I mean, just basically the regulatory approval will take anywhere between 4 to 8 months at least. And then once the liquidator comes into, takes control of the company, we can expect that to again take a year. From our experience, these are the estimated timelines which I'm talking about now, based on the scale of the operation, based on your pre-processes that you've put into place before it actually hits. These timelines can vary, because we've actually seen some companies which we've worked with, we've actually advised them to make all these pre-packaged plans ready to just file, and discussions already in place. Those approvals and processes have moved along much faster than the others. So that's my first sort of observation. Now, and generally with respect to, key considerations when we are planning to restructure, we look at the existing contractual obligations, conduct the DD, employees are a big consideration, because Myanmar does have a very, stringent employee protection mechanism. So we need to look at that as well. Regulatory approvals and considerations, and finally your documentation, and moving ahead with the step of either where it is a share transfer, it's a share transfer, where if it's an asset sale or loan restructuring or winding up, as the case may be. So that's how I would sum it up, Nishant.
Thanks a lot, Rohan. And Diber, similarly, the key aspects from a tax perspective for restructuring. But being conscious of time, let's just try to summarize it in the best possible manner.
Okay, so from a tax perspective, so you need to also consider what are the applicable taxes on your proposed transaction, whether it's a share sale, asset sale, or financing. You also need to consider your unutilized tax attributes, which could refer to input taxes, unutilized losses. Your exit tax consideration would also include securing of a tax clearance when you plan to repatriate money outside of Myanmar as a new requirement of the MOPF. Also consider any form of a relief, whether it's through a DPA, international agreement, or under the domestic rules. And at the same time, assessing on any potential liability that you will absorb when you purchase or you become the new owner of those shares or the assets.
Thanks, Diver. And I think so with this, we have summarized and tried to give that 360 landscape of restructuring of businesses in Myanmar. We would be happy to receive any questions which you may have. We haven't really seen questions raised. I think so we were very clear in our presentation. That being said, we are also happy to receive any questions which you have on our emails. Our emails are provided on the screen. Please feel free to reach out, and we will be happy to respond to you. All right, with that, I think so the webinar has come to its logical conclusion, and we hope to be more informative and covering more similar topics in the future, which is important from Myanmar market perspective. So until the next time, we are signing off. Thanks a lot, Diber. Thanks a lot, Rohan, for your time and your presentation.
Thank you.
That was very informative, and we hope to continue this process in the stride going forward. Thanks a lot. Bye-bye.
Thank you. Bye.